It's a lot easier when you're in a room with nothing but lawyers. When you get clients in there, you're a little bit more restrained in what you say.
Yes, yeah. Your Honor, with regard to ALEEM, Your Honors, excuse me, with regard to ALEEM's case, the primary argument that I wish to make is with regard to the closing argument of the prosecutor. We have argued, it's our very first argument that I'd like to make.
Which one do you think is the worst thing he said?
Well, let's see. The very last thing that he said, where the entire case was built on speculation and etc. I mean, its impact was powerful because he's speaking from the position of authority of the assistant.
Read which argument it was and what he said to us, so we can.
So what he first did was he went over. He ridiculed the defense theories right before that, and then he says, and he tries to argue his case, and he says, how do you get over our evidence? How do you get over that? With supposition, with conjecture about where something could have happened, why something happened, what someone didn't do. It is what it is. He did. Ali committed the worst act a parent can ever commit on a child, and then he chose to come in here and testify, concocting a wild story. So he's trashing, he's ridiculing the defense theory and all of their evidence as supposition and conjecture.
And if that's all he said, would that be enough?
No, but there's 14 other incidences.
All right, but let me ask you, on that act, that would go to the act they found your client not guilty of, correct?
I'm sorry, I don't have a hearing.
That would be the act that they found your client not guilty of, as far as his sperm on her rear, in her rectal area. They found your client not guilty of that one, correct? They just found him guilty.
Not guilty of. No, there was no charge of anal. For him, he was only charged with oral and vaginal. Vaginal in count 1, oral in count 2. Right. He was not charged with
Now, would you agree that the main difference between the evidence as far going to the oral sex and the vaginal sex was your client's statement to law enforcement?
Oh, absolutely, Your Honor.
Okay. What were the improper comments that you're saying bolstered the police officer's testimonies?
Okay. Well, what the prosecutor did at one time, and it's on page 19 of my initial brief, he was talking about Detective Cronin and the particular statement that ALEEM made to Detective Cronin. And this was a crucial issue in the trial, whether it was voluntary. Even though the judge had determined in the motion to suppress it was not, it was admissible for constitutional purposes. Whether it was voluntary is a jury issue. And he argues, and it's on page 19 of mine, he says, and the statement to Detective Cronin, that's pretty straightforward. Either you believe Cronin is a rogue or he's telling the truth, right? And then he says, quote, and the truth was in the defendant's own handwriting. And I submit to you that is a manner in which, in the context of the argument, he was bolstering Cronin's credibility, who said, I did not coerce him, I did not threaten him, he did not write down what I told him, and that's precisely what the defendant testified. He said, I was tired, he was coming in, he said, he'll let me go if I would just say something, so he told me what to write and I wrote. And if you read the statement, it is consistent with what the defendant said. And I mean, it's kind of gross, but it says, finger the pussy, get blowjob. It wasn't a coherent sentence. It was like something that you would write down as somebody is telling you. And I submit that that was a critical issue in this case, especially where the jury acquitted him of the vaginal sex, where they absolutely said, implicitly say, we reject the testimony of the victim. It appears that that statement to Detective Cronin was outcome determinative in this case, and throughout the closing argument, the prosecutor is expressing these personal opinions of the guilt of the defendant, of the truth of the statement, the critical statement that resulted in his conviction. Your Honor, as a first statement, that's the guy who did it. It was at his hand that she lost her innocence. She's going to, and the truth was in the defendant's own handwriting. He goes on to say, I submit to you he's lying on the stand. He's lying right now or misleading the jury or the court.
Isn't there some sort of...
Pardon?
I've seen cases both ways on the he is lying argument. What makes this one fall into prejudicial error? Because
there were two critical credibility issues in the case, the credibility of the victim and the credibility of Detective Cronin, right? He essentially won on the credibility of the victim. The most serious allegations was 4 vaginal batteries, all right? They rejected that. They acquitted him of that. There was no charge of anal sex, although her testimony was that he had anal sex. It comes down to the oral union count. And he's saying, yeah, I wrote that, but it was 36 hours. I had no sleep, and Detective Cronin was forcing me to write that. And I submit that every time the prosecutor is bolstering the credibility of Cronin and mocking and ridiculing the defense's case, that credibility issue is paramount. When the prosecutor said the truth is in his own handwriting, that irrevocably sealed his fate, because the prosecutor expresses his personal opinion on the guilt and basically tells the jury that Cronin's right, he's wrong, and this is the truth.
Let me ask you about this one, folks. Yeah. He says, this is page 478 of the transcript. And finally, in the end, the mountain that he cannot climb, the mountain that can't be climbed by anybody, is the one simple question, because I would love to know if there's any justifiable reason for why a father's semen should be in the rectal swab of his daughter. Please speak up. Please speak up. Why was the rectal swab involved in this case at all?
It was objected to. I believe the state, it was over objection of the defense. The state offered it on the premise that possibly semen could have leaked out of the vagina and, reposed itself on the anus. However, the testimony of the witnesses, that was the reason for its admission, and the testimony of the state's experts was it is impossible for semen to have migrated from the vagina to the anus unless there was at least trace amounts found in the vagina. And the evidence was, and the experts were asked, well, was there any trace amounts in the vagina? No. Could that have migrated? Absolutely not. So what I'm saying is that shouldn't have been in at all.
So if these comments were so bad, Counselor, why weren't there any objections?
There was objections to the admission of the DNA swab.
Yeah, but we're talking about the closing argument, essentially. There was no objection at all during the closing argument.
There were no objections in closing argument, but that's not the test. The test is...
Sure it is. It's a matter of preservation of error.
Well, no, we're arguing fundamental error, Your Honor, and the test for fundamental error, as stated by this Court in its service opinion, and if I may quote, fundamental error in closing arguments occurs when the prejudicial conduct in its collective import is so extensive that its influence pervades the trial, gravely impairing a calm and dispassionate consideration of the evidence and the merits to the jury.
See, here's what bothers me about that. I'm not really good at being cagey in these things, by the way. If they acquitted him of the vaginal sex, then why would the admission of this evidence, I mean, that suggests to me that this jury was quite deliberative and that they were going to, weigh the evidence. Why, since there was an acquittal on the vaginal sex, why are we to leap to the conclusion that these erroneous comments were fundamental in nature? The suggestion to me would be, since there was an acquittal of the major items, that the conviction of the minor item was less, was certainly not influenced by the. And by the way, I think the prosecutor went overboard on this. I don't think there's any question about it. But I'm really troubled by the fundamental nature of it.
Your Honor, my argument is that it did pervade the entire trial and that there were two credibility issues. The credibility of the victim, which was rejected, at least in part, possibly completely, and the credibility of Detective Cronin, who claims he did not coerce the defendant, and the defendant who claims he did. And they have a statement in his own handwriting that says, I got a blowjob, right? And
Let me ask you about
saying it's the truth, while the defendant's saying, no, it's not.
All right, let me ask you about that last sentence that you say sealed your client's fate, and the truth was in the defendant's own handwriting. Now, would it have been permissible for the prosecutor to say, and I submit the truth was in the defendant's own handwriting?
Yes, that is absolutely permissible, but that's not what the prosecutor said. And throughout the entire closing argument, he's giving his personal opinion, and I do believe it makes a difference. And the courts do routinely find error, find impropriety when the prosecutor doesn't preface by this is what the evidence is, especially when he's, again, ridiculing and completely giving his opinion on every aspect of the defendant's case.
All right. You said there's credibility of two witnesses at stake here. One's the victim, one's Detective Cronin. Are there any other statements that you're saying were improper which related to the testimony of Detective Cronin, other than one you've already discussed?
I believe so, Your Honor, and I have indicated them in my brief. After each argument that I name in the brief, I indicate where I'm concerned the improprieties.
Why don't you save that for rebuttal rather than killing all your time?
If I may,
We'll give you a few minutes on rebuttal.
Thank you, Your Honor.
Don't touch anything.
I'm not going to. May it please the court, my name is Pam Kohler, I represent the state on appeal. Obviously, there's several allegations of prosecutorial misconduct, some of which, like whether or not the defendant is lying, the defendant became a witness and he claimed.
So hold on.
Okay.
Were there any of the arguments pointed to by Mr. Troncalli that you agree should not have been made?
I would agree some of the language is a little bit over the top. But on the other hand, this is pretty horrendous crime. I mean, we've got this little girl who's raped by her uncle and her stepdad. This is the man that has been her dad since she was 6 years old. And I think when you look at the facts in this case, I mean, to a certain extent, a prosecutor's allowed to make arguments.
Isn't that the kind of case where a prosecutor really needs to watch himself or herself?
Yes, but on the other hand, I think juries also understand that a prosecutor would become dramatic and use such language.
I don't know how we can conclude that.
Well, I think you can.
I was really amazed by 3 sentences in your brief. Finally, it was clear from the content of the prosecutor's arguments that he was perhaps overly fond of using dramatic language. The problem, of course, with relying upon dramatic language is that it loses its impact the more it is used. The state would suggest that in this case, the jury probably figured out that the prosecutor was overly fond of dramatic language and allegedly improper comments did not have the effect alleged by appellant. Under that theory, as I understand it, the more he talked, the more likely it was that the jury was going to. So the more error he committed, the better it was for the defendant.
Well, the more he was overly dramatic. I don't think juries are as dumb as we think they are. I was a prosecutor for 6.5 years.
I'm absolutely convinced they're not.
I think, if you've got a prosecutor or any attorney up there getting very dramatic and using these, outrageous, ridiculous, presumptuous, I think a jury starts thinking.
You're getting overly dramatic.
And I think a jury just kind of sits there, oh, please, and I think the fact that they found him not guilty on one count shows, you're not going to persuade us. We're not going to find someone guilty just because you're overly dramatic in a closing argument.
I think there's at least 6, maybe more, out-of-bounds arguments made by this prosecutor, and they really trouble me. They trouble me because it's not his job to be overly dramatic.
Sure, but, we also have very strong evidence in this case, and you have to find that it vitiated the entire trial, and this verdict could not have been reached without this fundamental error. And I don't think we can find
the
that.
jury found the evidence was not strong enough except as to his written statement. And that put him that put the state over the top as to one of the 2 counts. Do you agree with that?
I don't think so. We've got so much evidence. We got the DNA evidence, which...
Well, the DNA would apply to both crimes.
Right. We've got his own confession, obviously. We've got the 911...
It applies to one.
Which, we got the 911 call where she immediately identified... she calls as soon as they get back, and she, calls them up and says, my uncle and my dad just raped me.
I'm just saying it can't be that strong if the jury came back not guilty on one of the 2 counts. And best I can tell, the only real difference between the 2 counts was the defendant's written statement. In other words, without that written statement, it appears the jury would have come back not guilty on both.
Obviously, a defendant's confession is very persuasive to a jury, and I think a lot of times they feel very comfortable finding someone guilty if they've admitted to the crime versus if they haven't, How
can we keep a prosecutor from doing this? This isn't the first time that we have cases like this where the prosecutor's definitely gone overboard.
Short of reversal, how do we teach that lesson?
And I certainly will speak to the prosecutor after my oral argument and explain what went on, and hopefully he's watching this oral argument and will understand the court's...
See, I think he was dead wrong. I really do. The only question I have in my mind about this is whether it's fundamental. That's where I've boiled down. I've studied this case a lot, and I'm down to whether it's clear error as far as I'm concerned. It's just whether it's fundamental, and that's where I'm troubled.
Well, and I think, we have enough evidence in this case that it isn't fundamental error. I think that there's enough evidence to support the conviction here, regardless of the closing argument. I don't know. I don't know if, because I know there have been plenty of written opinions saying you're not supposed to do this, you're not supposed to do that. And I understand attorneys also get very caught up in cases like this. These are cases that get under their skin, too. So, I don't know. Reversing this would only, this victim then would have to come back into court and testify about this, and we'd have to go through all this again, and I think he'd be convicted again. Obviously, we'd only go back on the 1 count, not on both counts, but, I think that there's clearly enough evidence. That she had, I think, they only had the penile of the mouth, but, I think that there's enough evidence here that, and I think it's just such a horrendous crime that I think that that's what got under the skin of this prosecutor.
I don't know what got under his skin, but he really needs to learn to control himself in front of a jury.
Well, I will certainly call him after oral argument and say you need to watch the oral argument and understand the concerns of this court. And hopefully he's watching it now.
His job is to make sure there's a fair trial.
Correct. We have a higher
burden.
burden.
The conviction is important, but he also has to be fair.
Correct.
This was not fair by any stretch of the imagination. This was way overboard. And frankly, if there had been a couple of objections, of overruled objections to this, it would be an open and shut thing as far as I'm concerned.
Well, and I mean, we weren't there, but maybe that's, who knows as far as the reaction of the jury, and maybe that's why counsel did not object, and because they saw it wasn't having any effect on the jury. I don't know. Obviously, that's all speculation. I can't tell from this record. If this court has no further...
Something you might discuss, it would be helpful to us as an appellate court to videotape these closing arguments, because, you say he's being overly dramatic. When we read, all we've got is a transcript.
Sure.
And trying to determine from a transcript whether somebody's overly dramatic is a difficult task. Sometimes it's pretty obvious, but a lot of times, the whole tenor of the argument can change depending on what the person looks like as they're making it.
Sure. Yeah, I don't know how many courtrooms have the ability to for videotaping, but
Yeah, very few. Thank you.
Your Honor, how much time is it that I have?
We'll give you a couple minutes.
First, if I may, in response to, I believe it was Judge Monaco's question, what other comments were made directly affecting the Detective Cronin's credibility. On page 23 of my initial brief, I cite this one, and I think it's right in point. The prosecutor, ridiculed, he stated as follows: "That's the defendant's handwriting, by his hand, witnessed by Kevin Cronin." And here's the offensive one. And this is where we really get out of this world as far as ridiculous goes. "Just admit to me," and then he goes on, just admit to me, Mr. Ali, of having sex with your daughter. What he's doing is he's saying he's mocking the defendant's testimony, where the defendant said, "Cronin told me, just tell me what you did and you'll be able to go." And that's what the defendants testified to. So he's saying, just admit it to me. He said that he knew he was having sex with his daughter, but he would believe you that he was promised by a law enforcement officer, quote, "Just admit to me that you raped and sodomized your daughter. Just admit you did it, and we'll call it a day. You can go home and we'll act like nothing ever happened." That is unbelievable to the point of being incredible. It's just not plausible. It's just not believable. That was his primary defense to the voluntariness of the statement. That was the defendant took the stand. This was the most important testimony, the most important defense in this case, because because the jury already rejected the testimony of the victim. That one really did it. That and the other one that I'm telling you, ladies and gentlemen, it is the truth. And, Your Honor, I hate to say this, but I don't really care what happens to Carlos Mendoza, whether he's disciplined or given a Congressional Medal of Honor. I care only about whether there was a fair trial. And my client, I submit, based on what Carlos Mendoza did not get a fair trial, and it was fundamental error under the definition of this court in service. And there is one troubling aspect about this. And I just have to compare it to an episode in my life. We had Justice Department attorneys that would teach prosecutors, young prosecutors, how to try cases. And we had this one experienced prosecutor who was the teacher. That experienced prosecutor tried a case with 25 years of experience and walked over during closing argument to the defendant, put his hands on the shoulders of the defendant and said, "You didn't hear him testify, did you?" Knowing that it was going to evoke a mistrial, the defense, and why did he do it? Because he knew he lost the case. The defense attorney was placed in a position, my gosh, I believe I won the case, but if I object, I'll get a mistrial. I might not win the next case.
Counsel, we understand.
But this was the similar thing. I submit, analogous to that, he knew he hadn't sold the jury with the victim. And I'm submitting to you that it is just too telling that this prosecutor makes all of these arguments in that trial, but then you look at the Hafiz Ali trial, and there's no defendant testimony, and he has very few improper arguments.
Which came first?
ALEEM's. ALEEM's case came first. And he was up against the ropes, and at worst, there would have been a mistrial. I submit that there's too great a chance of it. It was intentional.
Thank
And
you,
my
counsel.
client was denied a fair trial, Your Honor. I rely on the brief for the other issues, particularly the motion to suppress, and I thank you for being heard.
Thank you, counsel. Court will be adjourned.